SJC-13273, Thomas Colpack and others, the Attorney General.
Hey, Attorney Baker, we're ready for you.
Chief Justice Budd, and may it please the court, Catherine Baker for the plaintiff appellants, and with me virtually are Louis Rizzoli and Matthew Brown. Initiative Petition 2103 should not have been certified to appear on the ballot because it violates the related subjects requirement of Article 48. The petition fails the relatedness test for three reasons. First, the Attorney General has not identified a unifying public policy because none exists. Second, the licensing provisions do not dominate what each other provision provides separately. And third, there's no operational relatedness because the subparts don't work together to further a unified public policy goal. At first blush, this petition appears reminiscent of another petition in the alcohol licensing context that came before this court in 2020 in Wiener versus Attorney General, but the two couldn't be more different. Where the petition in the Wiener case contemplated an integrated approach to lift restrictions on the number and allocation of alcohol licenses, the provisions of the instant petition do not all support and revolve around that or any other unifying policy. Instead, this petition begins with a popular proposal to gradually increase the statewide ownership cap on the combined number of off-premises licenses, including wine and malt and all alcohol. But if a diligent voter reads further down, she will see that it negates that provision with respect to all alcohol licenses, setting a maximum.
I'm not sure I understand why that's not related. Altering how many licenses there are per individual, maybe adding more for beyond just beer and wine, and maybe less if you have liquor involved. That's all related to gauging how many licenses should be out there. There's nothing about relatedness that says that internal regulations all have to be going in the same direction.
So I think the problem here, Your Honor, is that we're starting out by asking the voter two very separate questions. Do you want to increase wine and malt licenses? That has a very different public policy consideration from the question, do you want to decrease the full liquor license? So you're, from the beginning, putting the voter in an untenable position of having to make two opposite choices.
Well, now, they're not necessarily opposite choices, but they're within the same regulatory scheme. But it may well be that beer and wine accessibility at grocery stores makes sense as a regulatory matter, and that more care should be involved when you're dealing with liquor. I have no comment on whether it does or not, but either way, it's one regulatory agency dealing with one regulatory scheme that the referendum contemplates.
The issue here, though, is the relatedness test is not about whether all of the subjects are the same subject matter. We have a requirement that there must be a unifying statement of public policy that weaves all of the subjects together. So here, the Attorney General has represented to the court that her proposed unifying public policy for this petition is identical to the one in Wiener. But she had to change that policy statement in Wiener to try to hide the material differences that expose the relatedness problem. And her proposed replacement, altering restrictions on licenses, isn't a statement of public policy at all. It's just an abstract description that the petition's amending the law on a particular subject matter. So subject matter has never been the basis for relatedness in this court's precedent. If a public policy statement like the one that the Attorney General has selected here could qualify as a unifying policy, no ballot question would ever fail the relatedness test because it swallows the standard. You could imagine in cases where the court has found there was not relatedness, like the Gray case, which involved Common Core standards and standardized tests being released each year, the court specifically rejected a policy statement of new procedural requirements for educational standards. there is really no material difference between the type of purpose statement that we're dealing with here in the Attorney General's brief and that type of policy statement that was rejected by the court. And the danger is you're not asking the voters a particular question. You're not giving them anything to vote on. You're not taking a side. All of the other policy statements that this court has approved, in Hensley, legalizing marijuana; in Dunn, preventing farm animals from being caged in cramped conditions; in Weiner, lifting restrictions on the sale of alcoholic beverages. These are all questions you can ask a voter in a coherent.
Well, it's a pretty straightforward question. The question is whether you want to alter the restrictions on the number of off-premises licenses, and whether or not you're going to need to make some changes on enforcement if the overall numbers are going to go up. And of course, I'm putting aside the whole out-of-state license issue for a moment on the enforcement side.
So I think, Your Honor, it's important to go through this analysis step by step, because I do think that the Attorney General has kind of bypassed the related subjects analysis in favor of more of a comparison style view between the different petitions in other cases. So I do think it's important to kind of take this step by step. And if we assume that we can use this alteration of restrictions on licenses as the unifying purpose, we see though that purpose statement does not dominate across the other provisions of the petition. So we have this self-checkout ban. Now, what does a ban on buying wine through the self-checkout have to do with changing the allocation and number of alcohol licenses? There is no relationship.
Counsel, isn't the relationship that if you change the number of licenses, you increase the potential for underage people to be buying them? So you eliminate the self-checkout so you can reduce that risk?
So the problem with the self-checkout ban provision is that it doesn't contain an age verification requirement like in Weiner. So the Weiner case was very different. There was an affirmative requirement that licensees were going to need to check IDs. And that made sense because in Weiner, there was going to be a flood of new licenses because they created a new license type. And that type was being offered to potentially new entrants to the market that had never held an alcohol license before. So with that flood came this fear that potentially there was going to be more opportunity for the sale of alcohol to minors because the licensees wouldn't have had experience dealing with the sale of alcohol, and they would be letting all of these minors come through and buy alcohol. But here we don't have any of those things. We don't have a flood of licenses to begin with, and we don't have a sort of indirectly related provision dealing with age verification. There is no age verification requirement here. So, I think it's too attenuated to say that you're just making the assumption that there's going to be.
Seems like you're saying in Weiner the age verification was better, but if you're eyeballing somebody purchasing the alcohol, and if you're enhancing the fine if they miscalculate, then you're enhancing enforcement. Maybe not as well as Weiner would have done it, but you're enhancing enforcement.
I think this provision also ignores the reality that the licensees are under the same, have the same motivation to check IDs regardless of the channel of purchase. So as some people may be surprised to learn, there is no affirmative requirement to check an ID for the sale of alcohol, but licensees are motivated to do that because of liability on the criminal and civil side that they may incur if they do not.
Like a draconian increase in fine that's not just based on revenue from alcohol.
Yes, so that's a whole separate problem for relatedness that we can discuss now if that makes sense. So this new system of fines is meant to impose massive disproportionate burden on non-packaged store licensees, and they could radically change that market segment by creating strong incentives for those retailers to simply exit the market because these fines are going to be so high that they can't manage them, or they might take a suspension over a fine and shut down their alcohol business temporarily, or they may pass on these costs to their customers. So off the bat, we have a very important public policy that's being looped in with these other unrelated policies. The Attorney General suggests that this provision is operationally related to the alteration of license caps because she's saying steeper fines are appropriate for some retailers because there's going to be more retail chains that have more licenses. And because they're retail chains that sell other products, they have less knowledge about selling alcohol than a package store would. This is a non sequitur. We don't have to adopt that speculative rationale because
or is it a different rationale that they make much more money? They have big operations, and for the penalty to have a bite to them, it needs to deal with all of their revenues. I'm not saying it's fair, but I'm saying that there's a rationale that the penalty is strict enough and severe enough that will cause real pain.
But what does that have to do with this minor increase in the availability of licenses, though?
The act, as Justice Lloyd is saying, look, it rejiggers the licenses for grocery stores and package stores. It does a lot of different things. It's designed to really help the package stores, but look like it's helping the other stores. It's a camel. It's not a horse. And it may not be completely coherent, but we've not required complete coherence. And for the penalties, that checkout provision deals with the fact that, convenience stores now don't have somebody there, like when you buy your alcohol at the package store. So you need a change of provision there to accommodate that problem. They make much more money, so that sale of liquor thing may not be enough to really give them a whack. It all seems generally related. It just may be a sort of messy, but seems like it's a messy relationship, but it's a relationship.
I don't see there being any relationship above a marginal relationship. And what is happening here is these provisions are simply related to alcohol sales. And again, a subject matter is not a stand-in for a unified public policy that ties in each and every subject. And we can't simply look at this in a vacuum, in the abstract, and say, well, these all seem to be related. I mean, this is a segment of a market. And so, maybe we think these things are part of the same domain, but the relatedness requirement ensures that there has to be a unified statement of public policy that a voter can vote yes or no on, and each of the individual subjects have to be accounted for. So one, I think that stands out to me is this out-of-state ID provision. So this is a loosening of age verification requirements. So under existing law, you can use a Massachusetts driver's license and a few other types of licenses, and that reliance on those types can be reasonable for purposes of liability. But this petition wants—
So that's, in my view, by far your strongest argument. But why I think it's an amicus brief. Why isn't the response that, well, if we're increasing the amount of licenses, we're increasing the amount of licenses of stores near the border, and it seems reasonable then that there'd be another way to engage in verification.
The problem here is that the Attorney General has admitted that the out-of-state ID provision does not relate to the overarching policy statement that she selected. It doesn't relate to altering restrictions on the number and allocation of licenses. And right there, you've already failed the relatedness test. It must be related to the overarching purpose. What she says it's related to is another indirectly related provision, but you can't have that attenuated chain of relatedness. No case has ever held that you are able to connect one indirectly related provision to another indirectly related provision and somehow achieve operational relatedness. It must all relate back to the purpose. So we have this argument from the proponents in the amicus brief about the cross-border transactions. Again, purely speculative, not foreseeable that there are going to be more transactions being done across state lines. It's simply just an opinion and a speculative one. And according to the court in Wiener, it must be a foreseeable consequence that's being addressed. So, you know, if you push that operational relatedness standard to its limit, you swallow the entire relatedness standard. And we have to be very careful here, especially when we're dealing with a petition that is a classic case of log rolling. We're starting out with a very popular proposition that we're going to increase the entire statewide ownership cap, but buried beneath, we see, no, that's not true. We're actually going to decrease the ownership existing cap for the most valuable type of license. And then, you know, let's sprinkle in here some more unpopular things like the self-checkout ban, but we'll add in this out-of-state ID provision, which, you know, could be a sweetener. So this is the exact type of petition that the framers of Article 48 were so afraid of. And I would submit to this court that we need to do our best to serve as gatekeepers and keep this confusing petition off of the ballot.
Okay, thank you.
Thank you.
Attorney Sturman.
Good morning, and may it please the court. Ann Sturman for the Attorney General and Secretary of the Commonwealth. And with me is Adam Hornstein.
How do you manage to shove into relatedness this out-of-state license verification that's going in the opposite direction of enforcement that might be needed for increased amount of licenses?
Well, I think, Your Honor, one thing that's important to note is that Your Honor correctly observed a few moments ago that nothing in this court's relatedness case law requires strict internal consistency between the provisions of a petition. But second, if we look functionally at what the provisions of this petition does, what the provisions do rather, as you've observed, we've got the provisions that essentially alter the market for the retail sale of alcoholic beverages to be consumed off the premises. We've got some controlled growth in the number of licenses available for the sale of wine and malt beverages, while we are going to hold constant at the number of licenses for the sale of all alcoholic beverages. And then we've got some provisions that are designed, as this court's case law tells us, is permissible to address the consequences of that. And among those provisions are a couple of provisions that together seek to regulate the point of sale transaction, the methods by which the point of sale transactions for these retail sale of alcohol take place. So the drafters have said that in order perhaps to address a concern about increased possibility for underage alcohol sales, that they're going to eliminate the remote transactions or the non-face-to-face transactions, the self-checkouts, require that things be face-to-face, but at the same time, increase the number of the types of ID that the face-to-face employee can accept. So it's those two provisions work together to reconfigure the manner by which the transactions will take place under the licenses that and the increased licenses that this petition provides for. Your Honor, 2 years ago, this court considered and rejected a relatedness challenge to a petition to alter the number and allocation of licenses for the retail sale of alcoholic beverages for off-premises consumption. Now, 2 years later, a different member of that same retail market has proposed a law that would alter the number and allocation of those licenses in a different way. Their proposal is no less related than the one that this court approved 2 years ago. Although it seeks to accomplish its purpose in a different manner, the purpose remains nearly identical and the provisions are equally related. None of the differences that plaintiffs have pointed out between the Wiener petition and the petition here, 2103, are differences that are material for the relatedness analysis for the threshold bar of certification by the Attorney General.
Although the proposal 2 years ago was more coherent, right? It was sort of a pro convenience store, pro grocery store licensing scheme, and this one's kind of a mishmash, right? And so there was a voter could sort of have a consistency. The provisions were more consistent with each other. Here, they sort of cut against each other in different ways, right?
I'm not sure I agree with that, Your Honor. I think it is true to say that the petition in Wiener favored more growth and more unrestricted growth. It is as though, for example, the petition in Hensley had set forth a retail market for the sale of marijuana in the Commonwealth without imposing any limitations, right? So it is true that in terms of the amount of and pace of growth in the number of licenses, the petition in Wiener would have had a greater impact. That doesn't make the provisions of this petition any less related or any less coherent. It simply means that they are proposing growth in this one segment of the retail market, but in a more controlled and less wholesale way. So,
well, that's not how the opponents look at it. They look at it as, well, Wiener was pretty straightforward. You got the reduction and maybe even the elimination of per entity limits. And here, what you have is an availability of an increase for one aspect of liquor sales, but a reduction for another aspect, and if those are inconsistent with each other, and in Wiener, as Justice Kafka alluded to, you're moving to much less regulated and maybe even elimination on limitations on licenses. Dramatically different, they would say.
So, Your Honor, I guess where I would push back is on the characterization of what this petition does to all alcoholic beverages licenses. I don't view it as a reduction. It's not taking away a license from anyone who currently has a license. It is decreasing the cap on common ownership going forward, with an important exception for companies that already own in excess of what the new cap will be, 7. So it is constraining the future growth of those licenses, but it is not a reduction in such licenses. Nobody who has an all alcoholic beverages license today will cease to have one by operation of this proposed law, should it be passed by the voters. So the same way that this petition seeks to foster or permit a growth in the number and common ownership of wine and malt licenses, it seeks to constrain the growth of all alcoholic beverages license. And it's entirely reasonable for the proponents who might have assumed that voters might feel differently. They might feel like, you know what, I wish it was easier for me to buy a bottle of wine on my way to a friend's house, but that doesn't mean that I want to sort of let loose the limitations on the sale of hard liquor, particularly by establishments who are engaged in more than one business line. And I might worry about whether or not they are as strict in checking identification or in verifying the age of the person purchasing the alcohol. So it is always the case that for a proposed law that has more than one provision, as most of them do, that there could always be a hypothetical voter who might like one piece and not like the other. But as this court said in Hensley, that's not what our relatedness test tells us is required by Article 48. Article 48 asks whether it's fair to ask a reasonable voter to vote up or down on the petition as a whole. So first of all, I can conceive of a voter who might think these provisions harmonize perfectly. I'd like to make beer and wine sales more available, but I'm concerned about doing the same for hard liquor. But second of all, a voter who feels differently about those two provisions, as a hypothetical voter might feel about almost any initiative petition, is free to vote no if their concern about one of the provisions outweighs their favor for another of the provisions. If the court has no additional questions on the relatedness issue, I did want to touch briefly on the timeliness issue that the single justice had asked the parties to address in their briefs. Your honors will recall that in the Dunn case in 2016, this court issued guidance to parties who wanted to bring these types of certification challenges to the Attorney General's certification decision. And that guidance was animated by a concern that the parties and that this court have a fair opportunity to consider the significant issues at hand and have a fair opportunity to consider whether the petition is one that is fairly presented to the voters. Here, the plaintiffs have chosen to ignore that guidance and have really offered no reason for doing so. And they've ignored that guidance not by filing, for example, on February 2nd instead of February 1st, but they've waited till April. They waited till April, having the combined effect of forcing the parties to brief this in a quite expedited manner and forcing this court to consider the case in a quite expedited manner. And so what we urge the court is to give some meaning to the guidance that they provided in the Dunn case, to avoid setting up a perverse incentive where opponents who want to game the system, who want to challenge the Attorney General's certification of a petition, might choose to game the system by not suing in January, not suing in February, by instead taking those months to prepare their argument and prepare their brief, and then file suit in April or May, leaving the Attorney General, Secretary, and this court to scramble to brief the issues fully and consider them with the seriousness that they deserve. So although I encourage the court, and I believe that there is a substantial reason for the court to, on its substance, uphold the Attorney General's certification of Petition 2103 as meeting the relatedness requirement, we've also raised in our brief, and I urge you to consider in the alternative whether this petition may be dismissed as untimely.